So good morning and thank you for joining us for this Policy Interested Parties meeting. I am Amelia Boyd and I am the Program Manager for the Medical Commission. This meeting is being recorded. The purpose of this meeting is to collaborate with interested parties such as the public, association members, physicians, and physician assistants regarding our policies, guidance documents, and interpretive statements. The documents which will be discussed here today are available on the policy meetings page on our website, which is wmc.wa.gov. Kyle Karanen, who is our executive director, and Micah Matthews, who is our deputy executive director, are the presenters for these meetings. Attendees, if you would like to ask a question or speak, please use the raise your hand function. When commenting, we request that you avoid commenting on ongoing investigations or disciplinary cases. Please make sure your comments pertain to the agenda items. Are there any questions? Doesn't look like it. Let me get to our agenda. So the first item on our agenda is the procedure for processing complaints against medical students, residents, and fellows. This one has been through several iterations. Kyle, do you want to talk about this one?
Actually, I think this one is Micah's to
Yes.
address. He did the cleanup on it after the last policy committee meeting. I have the next one though.
Okay.
All right. Thank you, Amelia. And so as she said, this is our maybe second or third, fourth, perhaps fifth go around with this one. And so a lot of the strikeouts that you're seeing are an effort to remove the procedural operational aspects from this and convert it to a true policy. Just from a basic governance standpoint, we need to make sure that we're not presenting options for commissioners to vote on things like how staff processes a complaint, because a lot of that is already mapped out or it's in statute, so it's non-discretionary. So the focus here is to articulate clearly that when it comes to a student or a resident, and in some cases fellows, that we will be dependent on the complaint nature itself. We'll be referring a lot of those back to program directors, designated institution officials, supervising physicians, what have you, because as a trainee, we feel it's more of an appropriate way to resolve any standard of care concern, since they are in a training program and they would need to get that wrapped up in the training program itself before going on to more independent or autonomous practice. I know that we've received a comment from UW on this, and so we certainly will take that into consideration. But any discussion or comments or questions on this?
And I just wanted to note that the clean version is also in this packet.
Yes, it's much easier to read.
Yeah, the red line gets a little. Doesn't look like there are any questions or comments on this one. All right, the next one is the proposed policy for commissioner and pro tem recusal. I'll take it away.
Yeah, so this was before the policy committee in July, and we did get a fair number of folks who on the commission indicated that they thought that it was too prescriptive, and that they worried that they were going to inadvertently cross a line that they shouldn't. So the main change that you'll see, and Amelia, if you can scan down, it'll show up. I believe it's page 3. No, I'm sorry. Keep going. It must be 4, or who knows? Actually, I'm sorry. My My version is the old version. Here, let me pull up the packet on my computer.
Do you know,
Yeah.
which section it is that you're going to talk about?
Yeah, so standards for recusal, we basically pulled out, there was a previously kind of a grid approach of when commission members should consider versus must consider recusal.
Here we go.
And this is for the purposes of appearance of fairness. It's not really it's not really a financial conflict of interest, which the laws are very prescriptive and very clear. And so we're trying to offer guidance to commission members on when they should consider stepping away from a case um, in whatever capacity, whether they're on a hearing panel or they're serving as the reviewing commission member, et cetera. So there's there's hopefully less prescription to the commission members and a good deal more flexibility. I can tell you anecdotally for the folks who are here attending from outside the commission, we frequently encourage commission members to have that conversation with staff because they may only encounter it once or maybe twice in their 8 years as a commission member, where, staff, we see this a handful of times a year. So the main change is removal of the prior grid that was in the original draft, but the rest of it remains the same. That's all I have, Amelia.
Thank you. Are there any questions or comments about this document? Does not look like it. Oh, Scott, go ahead.
Hi, I was just wondering if you could speak to any attempts to be sure this is harmonized with the same principles embodied by the RPC, if there is any effort or if that's even worthwhile.
Scott, do you mean with relation to the rules of professional conduct for attorneys?
Yes, the conflict of interest principles embodied by that, they're kind of worked out to the nth degree, where n is much greater than one. And I was just wondering if there was any consideration to that, or whether that would even be appropriate.
I'm not sure that entered our conversation. We took a look at a handful of cases that have addressed this. There's not a ton of case law with regard to kind of professional licensing bodies. In terms of appearance of fairness, the principles that are in the RCW are pretty ironclad, and I can't really recall an instance where a commission member had a direct conflict of interest on a financial issue. So we were mostly concentrating at this point on the appearance of fairness doctrine. And so we looked at Naravetla, we looked at the Johnston case, both of which have pretty decent principles, but the RPCs for attorneys didn't enter into it.
Thank you.
Are there any other questions or comments on this one? Doesn't look like it. So Kyle or Micah, which of you would like to speak about this one? This one is just up for its 4-year review.
Yeah, I can speak briefly on it. We have not made any proposed changes to this, as Amelia is indicating. This is up for periodic review. I do think that there are some kind of percolating larger issues that maybe led to some of the original adoption of this document on behalf of the commission. But this is really, as Amelia mentioned, just periodic review. I don't see anything outstanding at this point that really needs to change or be revised, but I'd certainly be interested in other folks commenting.
Are there any questions or comments about this document? Does not appear to be. Right, and then The next one is our proposed interpretive statement regarding qualified physician under optometry law. And we did receive a comment late yesterday, which is included in the packet that is on the event calendar. And we can talk about that if you would like.
Amelia,
It's
I
a
didn't see
pretty,
that. If you want to go ahead and kind of outline the comment or share it on
sure,
screen, that would be great.
I'll share it. Yeah. In fact, I will probably just read it. Let's see. I don't even have it tabbed in here. Okay. So this comment is from the Washington Academy of Eye Physicians and Surgeons. And let's see. It talks about what SSB 5389, which is why I believe we're working on this particular interpretive statement. Okay, so it says SSB 5389 requires that an optometrist who qualifies under the statute for an endorsement to provide advanced procedures as defined in statute must have an agreement with a qualified physician, a medical doctor, or an osteopathic physician for rapid response if complications occur during advanced procedure. As the legislation was being considered, I don't even know how to say that, WAPS assumed that a qualified physician could only be an ophthalmologist since no other medical doctor would be inherently qualified to respond to an eye-related complication or an adverse event if one were to occur. Unfortunately, not all parties have agreed with that assumption, and the Board of Optometry has, in its meetings concerning regulations pertaining to SSB 5389, contended that any medical doctor or osteopathic physician could be party to signing the mandated agreements. This is not acceptable to us. They support the current WMC proposal stating that agreements must only be with an ophthalmologist with current or unrestricted certification from the American Board of Ophthalmology. They are joined in that support by the Washington State Medical Association, the Washington State Hospital Association, and the Washington chapter of the American College of Emergency Physicians. They opposed SSB 5389, increasing the scope of practice of optometrists because it felt so strongly that optometrists were not adequately trained to undertake the lengthy list of procedures permitted in the proposed legislation. One of the very few patient safety provisions contained in the bill to offset those concerns is the requirement for an agreement between an optometrist and a qualified physician to handle complications. These mandated agreements provide a vital level of patient protection. However, it is unrealistic to assume that a provider other than an ophthalmologist would be skilled or adequately and extensively trained to respond to a surgical complication or adverse event involving the eye or surrounding tissue. The terms complication or adverse event are not specifically defined in statute for ophthalmic procedures. Yet another issue regarding SSB 5389. Protecting vision or undertaking surgical procedures requires extensive training, which no other medical provider undergoes. It is therefore not sensible to assume that any other medical doctor would have the knowledge to provide urgent care. Timing is of the essence to respond to any of the potential complications of the advanced procedures authorized in SSB 5389. For example, if any complication were presented to an emergency room medical doctor, it is highly likely that an ophthalmologist would be consulted, which adds another step and more time before the complication is properly addressed. This unnecessary hurdle could lead to lasting health problems for patients that could have been prevented by requiring direct access to an ophthalmologist. Fortunately, in virtually all areas of Washington, there are ophthalmology practices, frequently in the same communities as optometrists. There should be no concern about the ability of an optometrist to contact an ophthalmologist with whom he or she has an established agreement for assistance in a timely manner. One other item of concern to them is regarding the maintenance of the agreements mandated in statute. There is no process currently in place to assure agreements are made, maintained, updated, or reviewed. They would encourage the commission to create a process to assure the agreements with ophthalmologists are established and kept on file. Again, these agreements are necessary for patient protection, and patients should be assured they are in place. They will be happy to provide us with further information if needed or requested. And they appreciate our pursuit of regulatory language to provide the quality care Washington's patients deserve and expect. That is the comment on our interpretive statement.
So I can follow up with a little bit of additional context, and I don't know if Micah wants to comment as well. We informally met with the Board of Optometry as they were going through the rulemaking that was authorized by Senate Bill 5389, to indicate that we had some concerns. You'll recall that a version, I think actually pretty close to this interpretive statement, was brought before the commission last year, and the commission elected to hold off on doing anything or adopting anything and allowing the Board of Optometry to kind of go through the rules process. As I mentioned, we met with them. Dr. Murphy and I met with them informally. I want to say it was I think it was the end of April, to kind of express the concerns. I think that the conversation was, certainly the invitation to talk was well received. I'm not sure that the concerns that we had indicated were as well received. And then we also said that we would be happy to come to a Board of Optometry meeting to talk to them in kind of more a general scope. In the meantime, we also sent them a letter outlining some of the concerns and some of the potential complications that not all physicians are probably comfortable handling from the procedures that were included in the scope expansion in Senate Bill 5389. I don't know. I frankly did not hear back from the Board of Optometry with regard to the letter. I know that it was discussed at either, I think it might have been a work group meeting of theirs. That letter is included in the meeting packet, the commission's meeting packet from the July meeting. My understanding is that the Board of Optometry is going forward with an interpretation of qualified physician that doesn't reflect the commission's concerns. In short, the Board of Optometry, the last time I checked in, was adopting a rule that basically said, as long as you're a physician and you're in good standing, you can participate in one of these kind of referral and treatment agreements. And again, we're not necessarily echoing every bit of concern that was in Dr. Kramer's letter and email that you just displayed. But I do think that there's still valid concern about the environment that the Board of Optometry is opening up their rulemaking on this. And so this interpretive statement is meant to, again, express the commission's concern that we only have people that have adequate training and experience dealing with conditions in and around the eye that are going to be working with optometrists under that scope expansion. Again, thank you to, I think it's WAEPS. I could be wrong on that, Amelia. I believe Miss Tracy's here, so she could maybe correct me if I'm wrong. But I think that this is an attempt by the commission to kind of underline the concerns about patient safety and care in light of the scope expansion in SB 5389. Micah, before we go any further, do you have anything you want to add to that? I know that you were involved in some of the initial legislative consultation when this was passing.
Yeah, so this is also the result of a sunrise review, and so when the disagreements between the board and the commission came up, as well as a number of the stakeholders, I did reach out and met with a number of stakeholders, as well as policymakers and legislators and legislative leadership on this, just to try to understand before we moved forward what their thinking was, what their intent was. I can unequivocally say that in those conversations that the intent is supported by what is in this interpretive statement. The idea that any physician can do this was not contemplated with respect to the term qualified physician, and so by us defining it as, because they are quite literally our licensees, and so it is up to us to define what is an acceptable practice for them, is deemed as appropriate. So with that, I'll cede back the time, and it looks like we've got a question from Billy, who can also pronounce the acronym for us.
Hi, everybody. Good morning. It is WAPES. This is Billy Dickinson with the Washington State Medical Association. Obviously, we represent physicians of all specialties. We've been involved with the rulemaking over at the Board of Optometry, and just want to share that we share WAPES' position on this, that only an ophthalmologist has the experience and expertise to respond to adverse events. And we are also supportive of the interpretive statement drafted here by the Medical Commission. Happy to answer any other questions. Thanks for the time.
Then I just wanted to add that when this was initially presented last year, the commissioners decided not to move forward with the interpretive statement, but they did approve rulemaking. So we do have an approval to start rulemaking on this subject, but we are holding off, waiting for the Board of Optometry to complete their rulemaking. So I think this interpretive statement now is until we start rulemaking. So I think that's why we're trying to establish it now.
Amelia, Mike, I apologize for my notes here are differing. Do we know, my recollection is that the Board of Optometry is moving forward with their rulemaking next week. Is that, am I in the ballpark there?
I thought it was the same day as our business meeting in October.
Okay. I stand corrected.
Mhm.
Okay. Thank you.
I think so too. Any other comments about this document or the comment we received?
This is Susie
Amelia,
Tracy.
sorry, go ahead.
Go ahead.
I'm Susie Tracy, and I am with WAPES, and I'm stepping in, I hope momentarily, for Dr. Kramer, who has participated with the Board of Optometry and is the author of the document that you so kindly read. I'm hoping she's just finishing up her a surgery. But I do think that all the points that she would raise were provided in the letter that she sent to you. I I think that we feel very, very strongly that the interpretive statement that you have before you is vital for patient safety. I think it's well worded. We would, I think it was mentioned in the letter that we would also think that there needs to be some clarity about whether agreements are actually signed and are on file. And we would suggest that you look at that option as well. As always, we are ready to work with you and appreciate all of your support on this issue. Thanks very much.
Thanks for that. Can I just comment on that briefly? You know, the idea of having these agreements on file or readily available is something certainly that has been discussed. I don't think that it's something that we can do in an interpretive statement from a kind of legal standpoint. That's not really the role of these. But I do think that, as Amelia mentioned, we have rulemaking that's been authorized. And I do think that that's likely to be discussed during the rulemaking if it goes forward. But thanks again, Ms. Tracy.
Thank you.
And just for the group and maybe my knowledge as well, Amelia, where are we at the point in this process for this interpretive statement? And what would be the next step beyond, I'm assuming, the policy committee?
So, right. So it will go to the policy committee, which their next meeting is September 26th. and it's also virtual. And so then if they approve that interpretive statement, it will go to the full commission at their October 11th business meeting, where they will approve it or deny it. If they approve it, it will then go to the secretary review. So they will be approving it for secretary review and not for adoption, because interpretive statements and policies go through that same system that rules do. So and then at that point, the secretary's office folks may provide us with some suggested changes or comments, and then the commission would consider those at their next policy committee meeting, and then possibly bring it back to the following business meeting. So it is a little longer process than it is for, say, a procedure or guidance document, because we have the secretary review process in there. It can take almost as long as rulemaking, but just not quite.
Thank you.
Any other comments or questions about this particular document? Doesn't appear to be.
I'll just
Oh, go
finish
ahead.
with one brief statement here, Amelia. You know, it's always challenging when the commission is looking at things like this, where another profession that's separately regulated has something that kind of calls in MD or PA licensees. And so it can be a very fine line for us to walk. The bottom line here is that, you know, we're concentrating on the expectations that the commission will have for MDs and PAs. We're not commenting on optometrists or the training or the other aspects of the Board of Optometry's rulemaking. And I just like to make that clear. This has come up a couple times in the past, certainly with regard to some aspects of collaborative drug therapy agreements with that involve pharmacists. But again, the bottom line is here, we are not seeking to regulate or impact other professions. We are concentrating on MDs and PAs. So just for the benefit of everybody that's attending, or maybe ultimately listen to this as a recording, I want to make sure that that focus is clear.
Thank you, Kyle. Anyone else have a comment? Okay, so everything on the agenda today will be presented again with possibly some feedback from this meeting to the policy committee meeting, which will happen on September 26th. You can find the link to register for that meeting on our event calendar on our website, which is wmc.wa.gov. And so all of the documents we talked about today will be discussed there. And so now I will open item 5, which is the open forum. Is there anyone who has any comments about an existing policy, or maybe a new policy that we could put in place, or any other items you would like to see us do with regard to policy or interpretive statements? It doesn't look like it. All right, well, thank you everyone for your participation. If you have any questions, you can email me directly. It is amelia.boyd@wmc.wa.gov, or you can just reach out through our website. We have a place where you can input questions and things like that. So if you have any questions, just reach out, and then if not, we will see you again probably on September 26th at the policy committee meeting. Thank you, everyone.